The following video is a brief history of a expression or statement you might see on the internet that is overtly being misinterpreted by people as a way to shoehorn a court case into going off the rails, and has never worked, because all you can do is either annoy the court system into letting you get away with something, or make them annoyed enough that they will make an example of you, which you will then use in your pity party later. Yes, I have a bias on this, but let's get to it. In the 1600s, if someone went missing or simply left town for a long time, their estates and properties could be declared abandoned and forfeit to authorities, and not any rightful descendants under some conditions. There were moves to do this after disasters. Why let any disaster go to waste? Legislation was then enacted, and this is the first one that pertained to presumption of death. In 1666, a French term translated badly to "he who lives" was used as the name for an act of 1666 called Cestui Que Vie, or Que Vie. Now, the reason I'm not bothering pronouncing it correctly is, if you're not aware of it, if you make a law have a deliberately obscure name, that's what's going on here, because this is a not French law. This is a different thing. But by deliberately obfuscating these things, when someone says you don't have ignorance of the law is not an excuse, this is the reason that expression at one time was a way to taunt someone, because it was. If you hide the laws from us, if laws are unwritten, they are considered invalid. In most cases, keeping things a secret means you don't want them known. You must notoriously and prominently display your intent towards the commoner. What did this rule do? It allowed an absence or lack of contact for some period of time to be determined at your location or whatever, to be a presumption of death, and not just to be abused by authorities as property abandonment for seizing property and enriching themselves. The authorities included the church, the state, a local warlord, or in some cases, just individual people in the area who decided to just take on property they claimed abandoned when it was obviously occupied with family members, because the person of note on paper had left the country because they went off to war. Every time a war occurred anywhere, people would wait for a period of time and they just sort of, while the place wasn't defended, take it. The church was absolutely mind-bondingly notorious for it, because the church would allow, under trust, a farm or property owner or just a house owner to basically rent the place either for no money at all or for a small fee, so they wouldn't lose the property during hard times. But then the church would come under new management and they would just steal shit. Well, you're in trust. Now, that's one version of a trust. One of many usages of the word trust in modern English. Various names were used in the past, again, to either make it really clear what the law is or obfuscate it. This is a history and pattern of abuse by the legal system and by those who are in power that people reference. And then there's the United States, where virtually all of our laws are actually laws we created for our own country. Most of the laws in this country are agreed upon of, by, and for the people. These arguments may not be a good thing to bring up in a country filled with individualisms that are very vindictive and in some cases in power as well. Statute Law Revision Act 1886, amended 1666, Cestui Que Vie Act, the Act, somewhat. The same Revision Law Act of 1888 amended and repealed certain words. I'm going to read it later if we have time. I'm going to see if I can do it. But it's poorly written, very bad English grammar. It invites misinterpretation, which people seem to love on the internet. Statute Law Revision Act of 1948 amended or omitted all of the text entirely, leaving barely any of it behind. And Presumption of Death Act of 2013 fully superseded and replaced what was left of it, and also made it to where, if you might have not figured it out, made it to where invoking this French expression of 1666 to not be allowed in court or in the proceedings, or to not be allowed in any further documentation. We are now in 2025. Where these acts occurred, you'll have to go look up. Let's move on. Different legal jurisdiction standards exist for the declaration of being effectively presumed dead. Absence and lack of contact, both, is allowed to be a presumption of death generally if it goes for 7 years or more. So a beneficiary could gain rights to a property or an estate, and in some cases is granted under presumption that this is tentative. They have power over it, mostly to maintain the estate, maintain the property, and then at that point submit a demand to have control over it, power over it, or ownership, versus being a custodian in trust. Now, again, one of the rules of people who are lying or doing a scam is ambiguity. Ambiguity is the friend of the devil in this case. And the devil is the person usually posting those YouTube videos or Facebook postings you saw. But under all conditions, Cestui Que Vie Act 1666 or Cestui Que Vie 1666 has no current effect in law. It has no outstanding need to be invoked, and invoking it is a red flag to the court that you're attempting to dig up something that has been completely nullified. Now, by saying completely nullified, some people are immediately going to flip out and start talking about Black's Law Dictionary and 100 other things. Shut up. Manifest Destiny, some act done by the Pope 1,000 years ago, they don't actually apply right now. Why? Because they don't. There's no in perpetuity of a human act. We're in the meat space world. We are real people here. Blood and bone humans. Conspiracy theorists don't make this clear to anyone. It's all kept hidden. Occulting it. You have to buy into their assertion that you can do stupid things like invoking these words on a piece of paper to pay a utility bill that you signed off on an actual contract instead of an imaginary one, where you said that you will pay a bill every month of $20 or whatever for your utility bill, and then when you don't, they turn off your utilities. This is not complicated. Throwing this in there to muck up to muddy the waters is a tactic, not a truthism. Example, plaintiff alleges the following under 1666 Act. The United States presumed that he was dead or abandoned his estate. The USA was and is acting as the custodian of this estate, pursuant to Cestui Que Vie 1666, etc., as well as claiming the Emergency Banking Act of 1933, House Joint Resolution 192, as House Joint Resolution 192, HJR, blah, 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 as public law, yada, yada, 1933, all gold was and are considered current gold seized by the government or property of the government, which is a little bit weird, secretly to make all property and citizens chattel in a debt value collateral in a bankruptcy of 1933 that did not happen. And again, I'm going to explain this very clearly. If your claim is that the entire United States pledged every hunk of dirt and every hunk of property and all the people in the United States as collateral in a claim, are you claiming this is enforceable? Now, this is the point where everybody starts screaming because they want to bring it up because they're trying to get out of a parking ticket or something. Just like invoking this 1666 no longer enforced rule that's no longer part of the legal system and cannot be invoked because we have rules here that are of, by, and for the people. This person's trying to get out of a parking ticket or paying his utility bill because the government had something happen back then where they did something that is not enforceable. It's not, you can't make all of us slaves to some bank somewhere. Then the person brings up a schedule of fees to muddy up the water some more. Specific monetary penalties he will claim and be allowed to just make judge, jury, and executioner for of infractions to him by claiming he is a trustee of a trust which supposedly owns him as a copyrighted trademark name based on his birth name. So you're the trustee, therefore in control of something that was done to you at birth or something. $10,000 if you try to interrogate the trustee unsolicited to give your name or driver's license, meaning, who are you? Do you have a driver's license? Oh, well, I'm charging you $10,000 for that. And $1 million for requiring any signature under threat, duress, or coercion, meaning you have to sign on the dotted line, you're not going to lie in court. That means every signature you've ever given was under duress. That means you can say, I get out of any contract I have, like for my utility bill, by saying this is under duress because I had no choice. Yes, you do. I've lived in an apartment and signed away my rights to have access to electrical systems and literally life-saving utilities because I couldn't pay for it for a 2-month period of time where I had no income and I had to live off of what I had until I got the next job that was going to happen in 2 months. I turned off the electricity, the water, everything. And they're like, why are you doing this? It's January. Because I can't pay it and it's January. I was able to pay my apartment fee for 2 months. I had no money left. Every time I earned money, I turned shit back on. I got everything turned on within 2 weeks, but I had to compel them to withhold life-sustaining heat and water because I didn't have a fucking choice. I can't be put into debt at that point. Why? In my case, I couldn't afford the debt. And because I had all this shut off, I then applied to have it turned on under emergency. They said, we're not going to help you with this as a poor person because you were able to pay your rent and paid your rent instead. What do you think all this is about? I paid for having a housing. So I was at a physical address. I was considered legally legitimate in the United States. If you're not aware of that, if you're homeless, you're considered almost an invalid and a ward of the state, even though you're not. That's how I kept from being homeless a couple of times, actually. First will and testament is then submitted to grant irrevocable power of attorney, the person's name, over the trust security name, the previous name. Meaning, I grant myself a power of attorney over myself, which is, by definition, the default status when you go in a courtroom. You're considered to represent yourself, even if it's a stupid idea, because they have to allow it. They just encourage you not to, and they provide lawyers, because lawyers know about all these obfuscated named rules, and know that this one doesn't fucking exist. An affidavit of correction, plaintiff asserts that his birth certificate had the wrong name on it because he says his birth certificate was in all caps and must be a fictitious name and therefore a company name. Which is bupkis because, if you're not aware of it, in this guy's case, it wasn't in all uppercase. He wasn't able to invoke it. The reason people use upper and lower case a specific way in different papers is because the letters are ambiguous. O and 0 look the same. I, L, and the number 1 look the same. This font issue is something that geeks like me have complained about for years. Below in the description, you will find a paragraph starting with, if such person or persons whose life or lives such estates have been misspelled, or shall be granted as aforesaid shall remain beyond yada yada. And then it brings up beyond the seas and all the other things you might hear about when these people bring it up. None of this text, or any of the revisions attempting to correct the spelling errors, is part of law anymore. It hasn't been for a long time. Since 2013 explicitly, and from 1948 implicitly, because only a couple of sentences were left over from it and were a footnote. Invoking laws that either don't exist or misinterpreting them so you can try to get away with crap that nobody else would be allowing you to in an of, by, and for the people country like mine is bullshit. Thanks for watching. Have a good day. Good luck with that. You'll need it.